Hey, Sean, how's everything going?
Good. How are you, Jim?
Pretty good. You working from home or are you going into the office?
No, I'm in the office today. I just always use the solid background because some judges don't like distractions. So
If I knew how to do that, I would do that. I'd like that blue background you have. I got to figure out how to do that.
well, if I can figure it out, it's pretty easy.
Yeah, it's like you look like you're on Face the Nation or
CNN.
something. You look like you've been trying any cases?
Not lately. How about you?
I haven't tried a case since the month before the COVID thing hit. I know, the Western District's open, and they're trying a lot of cases over there, but none in the Eastern District.
Yeah,
That's
no,
where most of my cases are.
yeah, yeah. I didn't know if the Western was actually trying cases. I know they've kind of opened up on the in-person hearings, but
Do you know Mike Dean from our office?
mm-mm.
I think he's tried 6, 8, 10 cases in the past few months over in the
Wow.
Western District. Amy's still with your office, right?
Oh, yeah.
She didn't want to do this argument.
I'm usually the one that does all the Sixth Circuit stuff. So for the office,
Okay.
I guess it's my beautiful face. I don't know.
Yeah, I don't know. Who was I just talking to? I think Judge Lightman, and he was saying that. Oh,
Morning, Your Honors.
Morning.
If everyone's ready, I can call the first case.
Would you do that, please? Thank you.
Yes, case number 201246, Kelly Rhodes versus the State of Michigan et al. Oral argument not to exceed 15 minutes per side. Mr. Cabot, you may proceed for the appellant.
Good morning, Your Honors. May it please the court, Sean Cabot, appearing on behalf of the appellant, Kelly Rhodes. At this time, I'd like to reserve 3 minutes for rebuttal.
Please.
As the court is aware, there are 3 primary issues that we're asking the court to rule on and reverse the decision of the district court. One, the appellant argues that the district court erred in dismissing the plaintiff's Eighth Amendment claims as to defendant McPherson. He's the one who prematurely lowered the lift gate. We argue that the district court also erred in dismissing the Eighth Amendment claim as to defendant Jones, who was the truck driver and the laundry cart flinger when he literally flung a nearly 400-pound laundry cart at the plaintiff causing the injury. And thirdly, we argue that the district court erred in dismissing the 14th Amendment state-created danger claims, where it was clear that the actions, or really inactions, of both defendants Jones and McPherson resulted in her significant injuries of a traumatic brain injury and numerous other significant injuries and damages.
Mr. Cabot, I'm sorry, and hopefully Judge Moore will give you 30 seconds. Mr. Farrell, will you mute your... It's not muted. It muted and then it went off. I'm getting a lot of feedback. I don't know if anyone else is.
Yes.
Okay,
I was.
that's much better. Okay, go ahead. I'm sorry, Mr. Cabot, to interrupt you.
No problem, Your Honor. I'll be fine. I know the court has read the pleadings and the filings and are familiar with the facts, but I do want to make sure that I point out a couple of facts that I believe are important and that set this case apart from some of the other cases. Number one, Miss Rhodes was 51 years old at the time this incident occurred. She stood 5'4" tall and she weighed 160 pounds. So she was not a young woman, and she certainly wasn't a large woman. And that becomes especially important when you consider that these laundry carts are on wheels. They can be over 6 foot tall, and that they can weigh 300 to 400 pounds. So obviously these carts loaded with dirty laundry can be taller than she was and can weigh twice or even a little more than she weighed.
Do we know,
Go
did
ahead.
the facts indicate what the weight of this laundry cart was?
They do not specifically. Throughout discovery, I mean, obviously there was never any investigation done to weigh the actual cart that fell, but the general consensus with the testimony by the corrections officers and everybody involved seemed to be that the laundry carts were about 300 to 400 pounds. At the very minimum, I believe there's testimony at the very least they would weigh 50.
Mr. Cabot, can I ask you a couple background questions on that? How did she get the laundry detail job?
So my understanding is that it's a voluntary position. And so I'm not 100% sure, but it would seem to be you could sign up for it. I know that there was criterion because it was termed, I think it was called a gate pass position, that you had to obviously have exhibited good behavior. You obviously couldn't be a flight risk, those types of things. And so when all those calculations were taken into consideration, she wasn't deemed a person who they thought would be a risk or thought would be any type of flight.
Are these the types of prisoners jobs that they pay for, or are they just gate pass jobs? Because go ahead.
I'm sorry.
No, I'm sorry, I interrupted.
That I don't know, Your Honor. I know this was a gate pass job. Whether or not she was paid, I don't know that that was brought out through the discovery in the case.
And one other question, what were her job duties?
Well, basically it was to assist in unloading and loading the laundry carts onto basically the 18-wheel semi-truck. And she was at an all-women's prison. There's only one of those in Michigan. And that was they would bring the semis in, they would unload the laundry carts and load them back on.
And was there any indication in the record about training that she had?
According to the record, she didn't receive any training from any officials. There was very little, I guess, on-the-job training, essentially by the fellow inmate that was with her. And again, this was only her second day on the job. There's no indication that sometimes in a workplace, traditional workplace, you watch safety videos or you read safety pamphlets, things like that. No indication at all in the record that anything like that was done, nor any indication that the officials here or any officials otherwise took these individuals, separated them, gave them any type of significant or really any type of training at all.
If you had to point to the best evidence in the record to show that Jones and McPherson were deliberately indifferent, what would you point to?
Well, I would point to their own testimony. Their own testimony, and then I'm going to pull it up here.
But specifically, what did they do that showed deliberate indifference?
Well, first of all, as to Jones, I mean, the record clearly established that he was already behind schedule. Everybody knew that these laundry carts were on wheels and that they were very heavy and very tall. And both Jones and McPherson and even Nolan, corrections officer Nolan, testified, these are dangerous jobs. People can be injured when these jobs are done.
But what did he do
or
fail to do?
So he's at the front of this semi, and he's supposed to warn them, and he's supposed to guide the cart down to where the hydraulic lift is. The testimony was very clear that he took this cart and literally just flung it down without any verbal warning. And then at the same time, we have McPherson prematurely lowering the gate. And of course, there was also the issue in the record of the lack of the wooden stopper, which is supposed to make sure that the laundry carts don't fly off the gate. They knew that wasn't there as well. And they didn't take any efforts, knowing that the wooden stopper wasn't there, took no efforts to deal with that. And there was no efforts knowing that the custom and practice was to announce, I'm going to be bringing this down, and to guide it down the trailer. None of that was done. He was late. He wanted to hurry and get it done.
Mr. Cabot, can I ask you about McPherson? So when he obviously says he didn't lower the gate, but I think Thomas said at one point in her deposition he did, and then at another point he didn't. It was, as I understand it, and you correct me if I'm wrong, as I understood reading the depositions, the laundry cart was already starting to fall when he may have started to lower the gate and then appears to have stopped it. Is that accurate?
I'm sorry.
No, I should have finished it. He didn't, the gate never went all the way down, as I understand, or at least I didn't see that in the testimony.
It didn't make it all the way to the ground, but my understanding is that it did begin to lower. And prior to, that cart getting on there.
Before, so you're saying it lowered before the cart getting on?
Right.
Okay. Thank you.
And so again, in answering Judge Moore, I think that's what Jones did. I mean, there was an established procedure that had been done. He acknowledged that, and it wasn't followed in this case.
And with respect to McPherson, was there not an indication that he saw that Rhodes was not paying attention? Is that part of the record, that he could see that Rhodes was not paying attention, but he continued to let the gate go down?
Yes, there was an issue with the district court opinion, and in the district court opinion, it talked about whether or not McPherson saw Rhodes. There was a question of, the district court pointed out, well, Rhodes was in his blind spot. But then there was also testimony that said, where he said, look, as I saw this cart coming down the trailer, I also see Kelly Rhodes. So it's clear there's a question of fact there that he did see her at the same time that this cart was coming down. Whether or not, I don't recall specifically that she wasn't paying attention, or maybe there was something about looking away, but I don't think there's any indication in the record, nor do I recall the defendant specifically stating that she was somehow negligent or not paying attention, and that's the reason why this happened.
Mr. Cabot, in your brief, you cite a bunch of compulsion cases. Is there any evidence they compelled her to stand there? Because at page 36 of your brief, you say that Jones directed her to stand at the end, but when I looked at all the sites for that, Thomas says, no, I told her to stand there. We rotated and took turns standing there as the carts came down. So I'm just wondering if there's any evidence Jones or McPherson directed her to stand there and where I can find that in the record.
I'm not aware at this point of an order of that, but I do know that that was how this particular loading and unloading process was done.
So
And
it's
I
a
could-
common practice versus
Yes.
a compulsion.
Right. And also along those lines, Your Honor, the fact that if she was doing something wrong or if she was not in the correct spot, there's no evidence in the record that McPherson, Jones, or anyone else, a prison official for that matter, told her to correct her conduct. And so that lack of evidence also indicates that they acquiesced and they agreed that she was doing what they expected her to do.
Is acquiescence enough? Do you have any cases for that proposition?
I don't have any cases that we cited in our brief, but the fact that they knowingly saw her, they were aware of what she was doing and didn't correct any of her actions, I think that shows that they had a duty to certainly correct it if they saw anything wrong, and they didn't do that, Your Honor.
If inmates complain that the weight room has no safety equipment, for example.
I'm sorry you broke up, Your Honor.
Oh,
on the
my
first
bad.
part.
If the inmates complain that the weight room has no safety equipment and then get injured lifting weights, would that be subject to the Eighth Amendment? Obviously,
I mean,
if those metal plates fall on your foot or something, it's dangerous. A 45-pound weight or as much as they lift.
I mean, I think it could.
Okay.
Mr. Cabot, Judge Daughtrey here. Are you hearing me?
I am, Your Honor. There's some feedback on your end, but I can hear you at this point.
Okay, let me just ask a question quickly. About the stoppers, were they normally on these trucks or not?
Yes, they were.
So why was there not a stopper on this particular occasion?
I don't know the answer to that. I don't know if that was ever determined, Your Honor. But I do know that they were aware that there was not a stopper on that day. Thank you, Your Honors, and I see my time is up. Unless
Thank you.
the court has any questions. Thank you.
You'll have your rebuttal time. Thank you. Mr. Farrell? You're on mute now. You need to unmute.
There. Okay, I'm sorry, I couldn't unmute it. Good morning, Your Honors. I'm Jim Farrell. I'm an attorney with the Michigan Attorney General's Office. I represent the appellees in this case. I give a very short statement. You know, the court below got it right. It's a very careful and thorough review of the facts and the law. It's a well-reasoned decision. My contention is this court should hold similarly, and I can address any questions you have. I can, you know, I sat through the depositions. I interviewed most of the people. I could answer your factual questions pretty well if you have any.
Well, my understanding is that the district court did find that Jones, at least there was a genuine issue of material fact vis-a-vis Jones on the deliberate indifference claim. And then the district court went off on the question about whether the law was clearly established. Is that correct? So you're conceding that there is a genuine issue of material fact vis-a-vis Jones? I
would agree with that. And, you know, the allegation of that his conduct in allegedly shoving the laundry bins toward the back, toward the tailgate was reckless. I mean, I don't agree with it. I don't think the evidence supports it. And, you know, just to point out the plaintiff's explanation, I mean, the complaint, you know, it's all couched in terms of negligence. They failed to train, they failed to do this, failed to do that. And it's only through her testimony that you get this factual statement that he was flinging the carts. But, you know, you listen to Jones is not a big guy. And he said, you know, these carts can weigh 50 to 400 pounds, depending on how much clean laundry is loaded in them. And he said it took all of his weight and all of his strength to wheel those things from the from the front of the trailer all the way back to the tailgate or to the lift gate, and that they're on caster style wheels. And he said those wheels you can't shove it in a straight line and it will turn. It causes these caster wheels make the thing turn. He said and so the way he would do it is he would push and pull these laundry bins out to the lift gate. Once there were two laundry bins on the lift gate, then McPherson, who's standing on the outside with a handheld controller, would announce that he's going to lower. He would lower it, start to lower it, and the two of the three laundry porters would stand there with their arms up to steady these bins. The thing would lower down. They'd wheel them away to the other woman, the other laundry porter. And so they would do that. And then when they were done doing that, they would reverse the situation and start loading the truck with dirty laundry.
So essentially, the state prison was relying on two women dealing with two carts that weighed up to 400 pounds to steady them. So what on earth, a normal person would not have the strength to stop 400 pounds from moving if they weren't a weightlifter.
Nobody assumed that they would do it. In fact, the testimony from one of her co-porters, or one of the co-women, or one of the other women who was
prisoners. They're prisoners.
The prisoners. The other woman said we trained her and told her if these things start to tip, get out of the way. And in fact, when it did start to tip, they yelled at her and told her to get out of the way.
Well, then why do you have people steadying them if when the minute they start to tip, the people are supposed to get out of the way?
That's a good question, Your Honor. I don't know. And I'll say this about the lip on those things, on the thing at the back, the lift gate normally had a metal lip, but on this particular truck, it didn't have that metal lip.
Is the lip at the end where the carts would go off, or is the lip
so
to the truck?
it was like a metal ledge or a metal bar right there.
Where?
Whatever was going to roll off of it.
Where would the normal bar be? By the truck end or by the end that's where people are standing on the ground?
Where the people are standing.
And so this one didn't have the lip at the end, and it didn't have the stoppers.
That's right. And the stopper was what they're talking about is because this truck didn't have that lip on the end of the tailgate or on the lift gate, the truck driver would use a 2x4. He'd set a 2x4 out there so it would stop these and prevent the laundry carts from rolling off the end.
And was that done? Does the record show that was done here?
It was not. I don't believe it was done here. Jones said he didn't think he was using that 2x4 at this time. He didn't think that was there.
Mr. Farrell, Miss Thomas testified that Jones often pushed the carts quickly and that no prior inmates had been injured. Is that accurate, other than maybe scrapes?
No, that's accurate. I was going to comment on that. Instead of, and the way I'd characterize what happened here was, Jones is a kind of all business kind of guy. And, he wouldn't stop and talk to the prisoners and stop and talk to the CEO. He was just, the testimony that he was flinging carts, I think is, in reality, he's a guy who works fast. And so he would bring the carts out, he'd put them on the thing, he'd walk right back, grab another cart, put it out on the lift gate, turn on. And he even testified he did not witness this accident happening because he'd already turned around and walked back to get another cart. And there's one other thing I wanted to note for the panel, and that's, this is a, I don't want to say a garden variety workplace accident, as the result of negligence. But it's close to that. And it's an auto liability case. I mean, plaintiff filed suit in the state court, seeking Michigan no-fault benefits. And we settled that claim. We settled all the state law claims, the no-fault claim, which is benefits paid without regard to fault. We paid her $50,000 on this case, but the plaintiff did not want to resolve these federal civil rights claims. And so we couldn't resolve those, but this is an auto type case. I mean, Michigan no-fault law applies to the loading
Mr. Farrell, is all that in the record?
Yes, it is.
Okay.
Yeah.
So what is your explanation for why this car tipped?
I don't know. I think it's, these, I don't know. I've seen these cards, they're all different shapes, and they're hard plastic edges, and they go up about 3 or 4 feet. Some of them even go up 6 feet tall. It could be that the laundry was misloaded. This is because they're unloading bins with clean laundry in it, and the laundry might have been misloaded. The load inside of the bin might have shifted and caused it to tip. The fact that when McPherson lowered it, he's got a push button handheld controller. Now it says, I'm going to lower it, and he starts to lower it, and that's when it started to tip. It could have been that the lowering itself caused the laundry to shift, caused the thing to tip off, but we don't really know. And, the thing tipped, and the testimony is that she was looking to her left, and McPherson's on her right. She's looking to, wasn't paying attention to the cart in front of her. It started to tip. Her Thomas, I think, was helping her, yelled at her to get out of the way. But interestingly, she claims that she suffered some additional hearing loss as a result of this skull fracture she got. But she was pretty deaf to begin with. And I think she did not hear her co-worker yell at her and tell her to get out of the way. And the thing hit her on the thighs, knocked her to the ground. She hit her head on the side of the pavement. It was a pretty bad injury. I mean, they didn't know if she was going to survive or not. I mean, she was bleeding all over the place. They responded immediately, got her to the hospital right away and all that. But, and I don't want to denigrate what was going on here, but this is sort of what one might call a garden variety workplace accident. Maybe I would say that, maybe the guy pulling the carts out might have been negligent. I think Mrs. Rhodes was negligent, comparatively negligent. So, but there's no evidence.
This is in the context of a prison. This is not a context of somebody outside in a laundry service environment. And so the question is whether there is something under the 8th Amendment that is actionable here. And things that you're raising, like maybe Ms. Rhodes was hard of hearing to begin with, wouldn't that go to the question whether there was deliberate indifference in allowing somebody who's hard of hearing to have a job that requires them to hear somebody yelling, get out of the way?
Well, I don't know.
Her being hard of hearing, I don't recall being in the facts in this record. I don't know if you can point us to somewhere.
I probably can't point you to anything. I just know I took her deposition that part of her damage claim was that that the injury exacerbated her hearing loss. And I know that we were trying to search for whether she had pre-accident hearing tests and see if she, what level of hearing she had before. I don't think we found any, but no, I would say I don't see evidence of deliberate indifference here. I see evidence of negligence. I don't see deliberate indifference, but.
Well, isn't there a Sixth Circuit case involving somebody who was a prisoner who was working in the prison library, who had a hernia and was told nonetheless to move bookcases and such? I'm blanking on the name of the case, but I
don't remember that case. I do remember Jones v. Michigan, and I read Johnson v. Campbell.
I think I may be messing up which case it is, but I think it's Smith versus Yarrow.
I'm not familiar with that case.
Okay, so hypothetically, if there is a case that says that an 8th Amendment claim can be stated when a prisoner has an ailment that is exacerbated by the work that they are doing in the prison, wouldn't that principle be applicable here?
I don't think so, because first you have to find deliberate indifference. And just an exacerbation of a pre-existing injury, that can be the result of negligence too. And frankly, plaintiff allegations in her First Amendment complaint are almost all negligence-based type claims. I don't see anyone here. There's no testimony, no evidence that anyone had inferred a substantial risk of serious injury. That people had said that this had never happened before. And this truck is there Monday through Friday. I mean, they do it 5 times a week. So there's no testimony that either of these two defendants, Jones or McPherson, had inferred that there was a substantial risk of serious injury.
Okay, so that goes back to my question earlier about why have women prisoners at the end of a truck whose job it was to steady the carts, which means to prevent the carts from falling over. There's no other reason to steady carts.
That's a good question, Your Honor. And you know what? I don't have an answer for. I mean, I agree with you. What's the point of them standing there with their, they're supposedly standing there with their arms up. What are they going to do? They're not going to push a 400-pound cart back onto the lift gate if it starts to tip. They're told to get out of the way. So what's the point of them even standing there? I don't even know. It sounds fairly, I don't know. Frankly, I don't know. I can't give you an answer for that. If I were in charge, I would have done it differently. But I don't see that as deliberate indifference. I don't see prison officials, aware of a substantial risk and then disregarding their risk. I don't see that. I think
Mr. Farrell,
yes, ma'am.
excuse me, just a minute. I have something in front of me that indicates that Thomas testified that she had witnessed laundry carts tip over multiple times. Are you telling me now that this had never happened before?
The testimony that Jones and McPherson gave was that it never happened before.
But what about Thomas's testimony?
Well, I don't, frankly, I don't recall Thomas saying that, but as the court said, she sees it in the record. I can't dispute it, that if she said it, she said it. But according to Jones, who delivered this laundry every single day, he said he didn't recall these things ever tipping off the back end. So I'll grant the court this, even if it had happened before, and we don't have any clear record if it had or had not. I don't think that creates any type of awareness, or I'm sorry.
Mr. Farrell,
yes.
Assume it had happened before. Were there any injuries from it?
Not that I'm aware of. No, sir.
Thank you. I see your time is up if you want to conclude in a sentence or two.
Yeah, sure. I think the court below, I think, did thoroughly analyze the facts and law applicable to the case. I think the lower court came to the correct conclusion, and I would urge the court to, in its de novo review, to do the same. Thank you.
Thank you. Mr. Cabot.
Thank you, Your Honors. Kind of piggybacking on some of the things that were just recently mentioned regarding the deposition of inmate Thomas. I believe that deposition testimony was on pages 37 and 45 of her deposition, where she indicated that this was not the first time a cart had fallen off. And she also testified that a cart had almost fallen off on her as well. So that kind of goes back to that testimony.
Mr. Cabot, any evidence there that there's any injuries from those? Just out of curiosity.
Not that I recall that she testified to. I know as far as Thomas, she said that it almost fell on her. So I know she wasn't injured, but I don't believe there was any indication that there was actual injury. But I don't think that's necessary in a case like this because as we cited on pages 15 and 16 of our principal brief, we have Jones himself who acknowledged, and this is page ID 683 and 684, he acknowledges himself that the loading and unloading of carts was dangerous. So there's already a knowing likelihood of injury that can occur. Even defendant McPherson, and I'm looking at page ID 715 and 716, he said that these carts posed a substantial risk of harm to inmates. And he went on to say on page ID 722 that an unguided cart, which in this case was testified to, he didn't take it with his hands and walk it down the trailer like he was supposed to. This was unguided because, as inmate Thomas said, he flung it. McPherson testified on page ID 722 that an unguided cart poses a significant risk of harm to the person receiving the cart. And that's why the carts were supposed to be guided. So again, you have evidence directly from the defendants themselves saying this is dangerous. And I think, I think the district court really went out of its way to grant summary judgment here. And then Judge Moore, I think the case, I quickly pulled it out as you were talking about it. I think it was Smith versus Yarrow, 78 Federal Appendix 529. That was a Sixth Circuit case back in 2003. And basically the court found deliberate indifference in that case where they made an inmate, and according to the case from what I quickly looked, did have a hernia, and he was required to lift things in the library and things. And they found, look, that there was that was deliberate indifference, and that was an issue to be submitted to the jury. And so based on our briefing and based on everything, Your Honors, I would request respectfully that the decision of the district court be reversed, and I see my time is up.
Thank you. Thank you both for your argument, and the case will be submitted. And you may disconnect now. We appreciate your argument.
Thank you.
I'll get the second case now.
Thank you. Looks like we're all here. Would the clerk call the case, please?
Yes, case number 205969, Memphis Center for Reproductive Health et al. Versus Herbert Slatery III et al. Oral argument not to exceed 15 minutes per side. Ms. Campbell, you may proceed for the appellants.
Thank you, Your Honors. May it please the court. Sarah Campbell on behalf of the state of Tennessee. I'd like to reserve 3 minutes for rebuttal, please.
Fine.
In preterm Cleveland, this court sitting en banc held that Ohio's abortion anti-discrimination law did not violate a woman's right to abortion. That holding forecloses plaintiff's argument here that the substantive due process clause bars Tennessee's similar anti-discrimination provision, but the district court preliminarily enjoined Tennessee's provision on a different ground, that it's void for vagueness. In doing so, the court egregiously misapplied the void for vagueness doctrine and engaged in exactly the sort of antagonistic statutory interpretation that the Supreme Court condemned in both Casey and Gonzalez. The district court
you're speaking about section 217 right now, not 216, correct?
That's correct, Your Honor. So there are two provisions that are at issue here, two parts of this recently enacted bill that are at issue. Section 217 is what I refer to as the anti-discrimination provision. Section 216 is what I refer to as the timing provisions, and those prohibit abortion at particular gestational ages. The district court also erred by preliminarily enjoining the timing provisions because it didn't even apply the now governing undue burden standard to those provisions. It simply invalidated them under a per se rule of invalidity that this court rejected in preterm Cleveland. I'd like to begin with vagueness. The district court made two vagueness holdings that weren't reversal. First, it held that the anti-discrimination provision's substantive criminal prohibition is unconstitutionally vague. It also held that the medical emergency provisions that apply, the affirmative defenses that apply to both the anti-discrimination provision and the timing provisions are unconstitutionally vague. I'll start with the vagueness holding as to the substantive criminal prohibition. The district court gave essentially two reasons for finding that prohibition unconstitutionally vague.
Ms. Campbell,
First, yes.
I'm sorry to interrupt you. Can I ask you a quick question about it? Does the statute require actual knowledge?
Yes, Your Honor. The Tennessee legislature has defined knowledge for purposes of the entire criminal code to require an actual awareness of the circumstances at issue. And the Tennessee Court of Criminal Appeals has interpreted that to require actual knowledge. We found no case that's interpreted it to the contrary. And you can contrast the definition of knowledge with the definition of recklessness in the Tennessee Code to see that recklessness does involve constructive knowledge, whereas knowledge is an actual knowledge requirement, Your Honor. And so that's one way in which the district court erred here. It held that the terms knows and because of, terms that are pervasive in federal and state statutory law, are unconstitutionally vague because the statute itself failed to define them. That holding was erroneous for several reasons. First, the Supreme Court and this court have made clear that a statute doesn't need to define terms if those terms have a well-settled meaning. The Tennessee legislature did define the term knows here. As I just mentioned, it requires an actual awareness of the circumstances or conduct at issue. And that term is also, the meaning of that term is well settled for purposes of giving defendants understanding of what that term means. So that although the legislature didn't need to define it, it certainly has here, and that definition squarely applies. The district court also faulted the legislature for not defining the phrase because of, but it didn't need to define that term because the phrase because of has a very well understood meaning. Both the Supreme Court and this court have held that phrase and similar phrases like by reason of or on account of incorporate the traditional standard of but-for causation. In fact, this court in United States versus Miller held that the rule of lenity required the phrase because of to be interpreted according to that traditional but-for standard, as opposed to a more ambiguous, significant contributing factor standard. So when the district court said that the statute—
if hypothetically, if a woman says to the provider, I would like to have an abortion, I'm very poor and I already have 3 boys, would her abortion be because of the sex of the child, or would it be because of her being poor, or is it because of both, or is it because of neither?
On those facts, Your Honor, I don't think that would give the provider the requisite actual knowledge that the woman—
But I'm getting to because of. He's heard her statement that I've given you. I'm very poor and I already have 3 boys. That would indicate that I think she's getting the abortion because of her economic circumstances. Why isn't it because of the sex? We don't even know the sex of this child. So suppose we do know that suppose we do know, add a fact, suppose we do know that there was what's very easy now, prenatal blood testing, I guess, that can tell you the sex of the child. It could, we really don't know the but-for cause. And in that situation— If she says, I'm very poor and I'm expecting a boy. I think the provider could think that the primary reason, the but-for reason for the abortion is that the woman is in difficult economic circumstances. I don't think that those facts would give her actual knowledge. And this is the key here. The statute has a scienter requirement. The statute requires the prosecution to prove that the provider has actual knowledge of that but-for reason. So plaintiffs are complaining that they really can't know the reason. It's difficult to know. But I'm gathering then that if a woman tells the provider that there are 3 reasons why she is getting an abortion, or 2 reasons. I'm getting an abortion because I'm having a boy and because I'm poor. That is all of those but-for. Sorry, Your Honor. That is not going to meet the but-for test. We don't believe it would. If all of those reasons play into the decision and the woman wouldn't have obtained the abortion for only one of those reasons, it was really all of those reasons contributing toward
the eventual decision, then no one of those reasons would be the but-for cause of her obtaining the abortion. But critically, just to return to the point I was making a moment ago, that the statute requires the prosecution to prove actual knowledge. So if it's true, as plaintiffs contend, that it's really impossible to know another person's motivations for seeking an abortion, then that's a problem for the prosecution, because the prosecution has to prove that the provider has actual knowledge that it's the but-for cause. And this is really the point that the Supreme Court in United States versus Williams and this court in United States versus Paul made, that the reasonable doubt, the vagueness doctrine, or sorry, the due process clause has multiple aspects that protect defendants. The vagueness doctrine is one of them, but allocation of the burden of proof is another. And the beyond a reasonable doubt standard allocates the burden, the risk of a lack of evidence to the prosecution. So it's the prosecution's burden to prove actual knowledge, and the fact that the statute has that scienter requirement alleviates any vagueness concerns, even if there were any, in the actual terms of the statute.
I see your time is going quickly, and you have not yet talked about the heartbeat provision. Could you address that?
Sure, yes, Your Honor. So the timing provisions, there are a number of different provisions, all of which are severable. The earliest one is heartbeat. The latest one is 24 weeks, and they're sort of incremental between that. Our position is that the district court did not even apply the undue burden standard, which preterm Cleveland makes clear is this universal standard that applies to abortion regulations. There were no findings that the district court made about which, if any, of these different provisions pose a substantial obstacle to abortion for a large fraction of women.
Well, just thinking about the heartbeat provision, as I understand it, once a heartbeat is found, the Section 216 would prohibit any abortion. Am I correct?
That's correct.
Okay, so why isn't that a substantial obstacle to having an abortion, that you can't have an abortion?
We recognize that for some of the earlier timing provisions, it is likely that such a finding could be made. That finding was not made here. The district court didn't engage in that analysis at all. But the
isn't
timing provision
it
started.
completely logical that if you cannot, and something like 80% of women have abortions after the time when normally a heartbeat is able to be detected. If something like 80% of women can't get abortions because a heartbeat has been detected, yet they want abortions, why isn't that a substantial obstacle to their having abortions? I don't know why we need a finding if you're correct that there wasn't such a finding.
Your Honor, the timing provisions, as I said, begin at fetal heartbeat, but they go all the way up to 24 weeks. We think that there is a point at which the state's interests, which include interests that are distinct from the interests that were at issue in Casey. They include the state's interest in protecting the integrity of the medical profession, the state's interest in preventing fetal pain, and the state's interest. Yes, Your Honor.
In your reply brief, you seem to kind of draw a line at 15 weeks. Can you explain the rationale for that to us?
Yes, Your Honor. So we do draw that line at 15 weeks for a couple of reasons. The first is that at that point, that there is a growing medical consensus that an unborn child is capable of experiencing, of not only having pain, but perceiving that pain at that point in time. We submitted declarations from Dr. Maureen Kondik and Dr. Robin Perucci that make that point. So the state has an interest at that point and prevents very strong interest in preventing fetal pain. And 15 weeks is the point at which plaintiffs, the abortion providers, begin using D&E abortions, which involve dismemberment of the unborn child. So we think the combination of those two things make the state's interest especially strong. In addition, are the data that we presented from from Ms. Loeffler shows that already well over 90% of women in Tennessee who obtain abortions get those abortions before 15 weeks. And we think that our large fraction analysis finds ample support and precedent. In Casey, the court said that the constitutionality of an abortion law should be measured based on the conduct of women it actually effects. And so, a timing provision like this affects not only women who might miss that cutoff, but it affects women who will change their behavior in order to get an abortion earlier. Preterm Cleveland makes clear that alternatives to abortion are important in the large fraction analysis. I see that my time has expired, Your Honors. Thank you.
Thank you. Ms. Buchanan?
Good morning, Rabia Mukadnam for Plaintiffs Appellees and Police Court. We are here regarding two sets of abortion bans. I'll touch briefly on the cascading bans and then turn to the reason bans and conclude with the medical emergency defenses. First, the district court correctly held that this first set of bans, cascading bans, are unconstitutional based on decades of Supreme Court precedent. And defendants have conceded that the only application of these bans is to pre-viability abortion. Under decades of Supreme Court precedent, this makes them unconstitutional. The district court also correctly held that the second set, the reason bans, are likely unconstitutionally vague, a claim that was not addressed in preterm. The district court correctly held that none of the state's arguments grapple with what makes this statute unique. The reason bans are unique, first, among other reason bans, and second, among all other criminal laws. First, all other reason bans have clarifying elements, such as in whole or in part or solely. Here,
I'm sorry to interrupt you. Can I ask you a question? Can the state ever ban abortions that are based on the race, gender, or potential condition of the fetus?
Your Honor, that legal question would go to a substantive due process claim, which is not before this court. The challenge is before this court here is
Can I ask you that? Are you saying we can't decide the substantive due process claim in front of us? I thought is it not in front of us at all?
It is not. Neither party appealed a decision from the district court regarding the substantive due process claim, so it's not before this court. Based on the court's recent decision in preterm, we submit that plaintiffs should go back to the district court and develop the record there. Here, the challenge is the procedural due process violation alleged under the vagueness doctrine.
So let me ask a follow-up to that. So assume then a state could, how could they do it in a way that would suffice in your mind under void for vagueness?
Well, there are a number of ways that states around the country have enacted reason bans that don't present the vagueness issue here. For example, most other states include elements like in whole or in part or solely, or they have other elements that provide physicians cover when they provide an abortion in good faith, that they believe that their conduct is conformed to the law. That's not the case here. The statute here is unique among both reason bans and all other criminal laws. And under the state's most recent definition, because of, as but for causation, the statute is particularly unique because it imposes severe criminal penalties based on a physician's knowledge of another person's but for motivations. The state has never identified an analogous statute, and they've never been able to articulate what actually violates the law.
Let me give you two. Ohio and California have various sexual offenses that require the prosecution to prove that the defendant knew the victim was incapable of giving legal consent because of some condition. Would those survive?
Yes, Your Honor. Invalidating the statute here would not affect such statutes.
What's the difference? Explain it to me.
Certainly. So as the court has made clear in United States v. Miller, assessing but-for motivations is a thornier question than simply understanding why someone did something or did not do something, or whether or not they did it. So in the instance of consent, for example, or an inability to provide consent, the analogous question as the statute presents here would not be whether or not the person had capacity to consent, but why they did not have the capacity to consent and the degree to which a particular motivation was a but-for motivation in those instances.
But wouldn't you, some of those cases in Ohio and California, you have to know the state of mind of the victim, right?
Certainly.
So why isn't that very similar in that it's knowledge because of the state of mind?
Well, in this case, knowledge is required of something that is indeterminate and vague. And that's, as under the state's current definition, the but-for motivation of a patient seeking abortion. As the Supreme Court stated in Williams, what renders a statute vague is not the possibility that it will sometimes be difficult to determine the incriminating fact it establishes to be proved, but rather the indeterminacy of precisely what that fact is. Here, that fact is, under the state's current definition, whether the patient was seeking an abortion for a but-for prohibited reason. And that's what makes this statute uniquely vague.
So if someone comes in and says, I'm getting abortion because of Down syndrome, you're saying that would be vague for a doctor?
There may be instances where conviction is more likely or less likely under the statute, but given the language of the statute, a physician could be prosecuted under a wide array of circumstances, and the statute fails to apprise them of when they can.
But couldn't you argue that in every knowledge plus but for case? I mean, we have hundreds, if not thousands of laws nationwide that have this combination.
Your Honor, there are actually no other statutes that impose liability on a physician or a defendant based on their knowledge of another person, a third party's but-for motivations. The states never.
But my point is, now you're tying it to the particular actor, but we've never done that. You look at the language of the crime, and the language of the crime, this exists throughout the country. And so I guess my question is, if we tie it to the language of the crime, aren't we potentially going to invalidate over 3,000 laws?
No, Your Honor. As the district court held, none of the state's arguments get at what makes the statute unique. Invalidating the statute will have no effect on other reason bans or any other criminal laws. The reason bans violate the void for vagueness doctrine because they fail to provide notice to physicians of what their conduct will be that violates the bans. And the state has never identified an analogous statute. And contrary to the state's assertion that the term knows or that knowledge is a clarifying scienter, as this court stated in DeWine, a risk of uncertainty in a statute may be cured by a knowledge requirement, but only if the knowledge requirement precludes prosecution if the physician believes in good faith that they've complied with the law. That's not the case here. A physician with a good faith belief that a certain motivation was not the but-for motivation could still be prosecuted under the law and would have no defense based on the fact that their good faith belief that they weren't violating the law or their ignorance of the law. I'll turn to the medical emergency affirmative defenses, if that's appropriate.
Certainly.
Finally, the district court correctly determined that both sets of bans are unconstitutional for the additional reason that they lack valid medical emergency exceptions. As the district court again correctly found, the ban's medical emergency provisions suffer from the very same defects as those invalidated for vagueness in this court's decision in Voinovich. They require a physician's medical emergency determination, a determination that in this court's own words is fraught with uncertainty and susceptible to being subsequently disputed by others, to be reasonable and made in good faith, while at the same time lacking any mens rea that would protect physicians from criminal liability if they did not intend to violate the law. Under such a standard, a physician may be held criminally liable if they believed they were acting reasonably and in accordance with his or her best medical judgment. And that
what if we struck reasonable, as the state suggests we do in their briefing? Go ahead, I'm sorry.
The state has argued that the term reasonable could be elided from the statute under Tennessee's doctrine of elision. We would submit that Tennessee's doctrine of elision is not applicable here because it would require a determination that the legislature intended to enact the statute without that term.
Why not just certify that question to the Tennessee Supreme Court and get a definitive answer then?
Certainly that path is open to this court. However, the Tennessee Supreme Court is not going to be able to provide a construction that would provide clarity to the statute for two reasons. First, one way of introducing clarity into the statutory language would be to import in whole or in part or solely, but that is clearly not what the legislature intended, given that all the reason bans that were examined by the legislature include other terms, and they explicitly chose to forge their own path here. And the other kinds, and second,
I'm sorry to interrupt you. Wouldn't that be an option open to the Tennessee Supreme Court, though? They can do anything they want to save the statute, and the severability clause basically says do anything possible to save it.
Well, the Supreme Court is still constrained by the prohibition on judicial legislating, and to rewrite those terms into the statute, that would be to basically rewrite the statute. And Tennessee law that provides medical emergency provisions in other contexts and other statutes that restrict abortion are different from. This is the only medical emergency provision that's ever been enacted by Tennessee with this language. If the medical emergency provision required only a good faith determination by the physician, that would not present the vagueness challenge here. But there is no way to distinguish this case from Voinovich, which has held that what makes this type of medical emergency provision vague is a combination of subjective and objective elements without a mens rea that would require that would allow physicians to rely on their good faith judgment.
Can I ask a different question related to that? Did you argue your vagueness claim below on a theory of arbitrary enforcement?
Well, as the Supreme Court has made clear in Collender, there are two touchstones to the vagueness doctrine. The first is the law's provision of notice to the defendant about how to conform their conduct to the law. And if there is latent vagueness in the statute, whether or not there is a danger of arbitrary prosecution because of that lack of a clear standard. Both the touchstones of that doctrine are present here.
Yeah, but I'm sorry, my question wasn't clear. Did you argue that below? Because I couldn't find it.
Yes, we did. I can.
No, you don't. I'll track it down if you did. Thank you.
Yes, Your Honor. I have a little time left, so I'll sum up my argument quickly. The reason bans impose an inquiry so indeterminate that the state has never been able to explain what actually violates it. It remains entirely unclear what role a prohibited reason must play in a patient's decision-making to trigger the law. This renders Tennessee's law distinct among all the reason bans and leaves physicians with inadequate notice about how and when they could be subject to prosecution. Second, the fact that defendants, those charged with enforcing the law, have provided inconsistent definitions only lends to the credence to physicians' fear of arbitrary enforcement. And finally, the law offers no mens rea requirement that could protect the physician acting in good faith. For all these reasons, the court should uphold the district court's well-founded preliminary injunction of the reason bans. Similarly, the cascading bans are clearly unconstitutional under decades of Supreme Court precedent. And as the state has conceded, the only application of those bans is to pre-viability abortion. Under Roe and Casey, that makes those bans unconstitutional under decades of precedent. And finally, the medical emergency affirmative defenses are unconstitutionally vague, which separately dooms the bans. Under Casey, any restriction on abortion must have a valid exception for when an abortion is immediately necessary to preserve the life or health of the patient. And so under directly applicable Sixth Circuit and Supreme Court precedent, that also separately invalidates the laws.
So your opponent was arguing here and in the reply brief that at the least with respect to the heartbeat provision, that 15 weeks was a cutoff because there was a different reason at that point, which was the fetus feeling pain. Can you address that? Should that be? She pointed to two doctors on her side that said that the fetus felt pain at that point in time. Was there evidence on to rebut that?
Yes, Your Honor. Plaintiffs provided declarations that contested those findings and have reflected the consistent medical consensus that was recognized also in this court's decision in EMW that is a practical impossibility prior to 24 weeks. But also, as the court in EMW recognized, even assuming the legitimacy of the state's interest in fetal pain, there is no state interest sufficient to justify a prohibition on abortion prior to viability. And
Can I ask a related question, which is, and not on the second part of what you just said, but on the first part, which is, don't we have to defer? Didn't the legislature make findings on fetal pain? And don't we have to defer to those findings under controlling precedent?
No, Your Honor. Legislative findings, as the Supreme Court has made clear, is not the same thing as evidence. In Whole Woman's Health, the court made that determination. And also in Gonzalez, the court recognized that those kinds of legislative findings are not dispositive of any factual questions. And in fact, the court made clear in Gonzalez that there was evidence in the record that actually contradicted the legislative findings. So the court is not required to defer to those findings, particularly where they are clearly out of line with the medical consensus as reflected in the evidence. But to return briefly to Judge Moore's question, there is simply no state interest that can justify a prohibition on abortion prior to viability. No one disputes that 15 weeks is prior to viability. And as the state has conceded repeatedly, this law only applies to pre-viability abortion. And in every application, it operates to deprive women of the ultimate decision to terminate a pregnancy. That is the central holding of Roe that was reaffirmed in Casey, that prior to viability, the state may not override a patient's decision-making, and that decision must be the patient's. And the patient's role is to evaluate whatever interests are relevant to her, and to make the ultimate decision to have an abortion. And so the cascading bans under decades of precedent take that right away. They directly police the heart of the right, removing the decision from the woman entirely. And that's why the district court recognized under many decades of directly applicable precedent, the cascade is clearly unconstitutional. And briefly to conclude, the reason bans also suffer from unconstitutional vagueness and imposing a procedural due process violation on physicians. And finally, the medical emergency affirmative defenses are clearly unconstitutional under Voinovich, and this court should affirm the district court's well-reasoned preliminary injunction order.
Thank you. Ms. Campbell?
Excuse me, could I have a question? Just out of curiosity, when this complaint was filed, listed among the defendants, in addition to Attorney General Slatery, are several local district attorneys. Why was that done, and how were they chosen, and what does that tell me about this case, if anything?
Certainly. The district attorneys that were named as defendants in this case are all of those tasked with enforcing these laws against the plaintiffs wherever they are located. So the defendants that include the district attorneys represent the counties where plaintiffs' clinics are located. But it's notable that although the actors with the obligation to enforce these laws are defendants in this case, they have never articulated how physicians can truly conform their conduct to this law.
Have they ever enforced it since the stay's been in place? Are there any as-applied challenges existing right now?
No, there are no as-applied challenges existing now. The record before this court is from the pre-enforcement challenge that was brought. But as plaintiff's declarations extensively make clear, there are a whole host of situations that will implicate the bans. And physicians are already curbing their conduct to ensure that they don't provide abortion whenever implicated reason is at issue.
But no one's been prosecuted.
No, no one has been prosecuted at present. I see my time is up.
Thank you. Ms. Campbell?
Thank you. I'd like to focus my brief time on rebuttal on the medical emergency affirmative defenses. Our position, as is expressed in our brief, is that Voinovich was wrongly decided, principally for the reasons that Judge Boggs expressed in his dissent in that case. We recognize that this court is bound by that precedent, but this court is not required to extend that precedent to a different context. And this case involves a different context. The medical emergency provisions here are affirmative defenses. They are not exceptions that are part of the criminal defense. The Supreme Court has said that the void for vagueness doctrine applies to laws that define criminal offenses and that fix the sentences for those. And the court has declined to apply it to different contexts. In Beckles in 2017, the Supreme Court declined to extend the vagueness doctrine to discretionary sentencing guidelines. This court should similarly decline to extend the doctrine to affirmative defenses. One of the main reasons for that is because a host of other general defenses that apply across the board to criminal offenses in Tennessee would be implicated. Tennessee has general defenses of necessity, self-defense, and defense of others, just to name a few, that employ the same reasonable belief standard. And Tennessee is not alone in that. Other states similarly employ a reasonable belief standard in their defenses. As Judge O'Scanlan said in his opinion in United States versus Christie, which we cite in our brief, the fact that extending the doctrine would call into question any number of criminal statutes, both federal and state, is a reason to decline to apply the doctrine in that new context. Even if this court finds that Voinovich should be extended to this different, distinct context involving an affirmative defense, it still doesn't require facial invalidation of either of the laws here. Gonzalez and preterm Cleveland make clear that the lack of a medical emergency exception is best addressed through as applied challenges, not through facial invalidation. In addition, that any ambiguity or vagueness in that defense could easily be remedied through elision. The question is not whether the legislature would have preferred to include the term reasonable. It clearly did because it included it when it enacted the statute. The question is whether the yes, Your Honor.
I'm curious, this medical emergency provision does not include an emergency based on mental health of the woman. Is that correct?
It does not, Your Honor.
Can you tell us whether that is unique, or can you give us examples where that has been upheld?
Your Honor, initially, I'd just like to point out that plaintiffs never challenged the affirmative defense on that basis.
I know,
This
I'm
court
just
in
curious. I was just curious.
Sure.
It struck me as interesting, shall I say.
Voinovich did say that a medical emergency exception should encompass mental health conditions. My time has expired. If I may briefly conclude. Thank you, Your Honor. But that holding has never been extended. And in fact, the court cut back on that holding somewhat in Taft and said that the medical emergency exception just must encompass any significant health condition. And we think Tennessee's medical emergency provisions here easily satisfy that standard.
Can I ask a follow-up, Judge Moore?
Sure.
Would that, if it was done for the mental health of the mother, would that be the but for?
Yes, Your Honor, our position is that the medical emergency provision is not even needed for the anti-discrimination provision. If the reason for the abortion is because of some health reason, either mental health or otherwise, of the mother, then that would be the but-for reason. And even if the woman initially wanted to get the abortion because of a prohibited reason, at that point, there would be two independently sufficient causes, and those are not but-for causes.
If hypothetically then a woman who has said that she wants an abortion because of a Down syndrome diagnosis, and the provider says, no, I can't do that because of the law, section 217. If the woman then deteriorates into a mental health crisis, then hypothetically in that situation, you would be saying that the abortion is not because of Down syndrome, it is because of the mental health situation, and it is allowable then?
Yes, Your Honor. That would be our position.
Okay, thank you.
If there are no further questions, the state respectfully asks this court to reverse the district court's holdings and vacate the preliminary injunction. Thank you.
Thank you both for your argument, and the case will be submitted, and you may disconnect, and the clerk may adjourn court.
All right, this honorable court is now adjourned.
Thank you, and thank you for all of your help, Ryan, and thank you, Ron. I'm sorry I'm losing my voice, but it's there.
I'll move you back to the robing room now, and then I'll come to the robing room just to make sure everyone connected, and I'll leave.
Great, thanks.
Thank you. Have a good day.
Thank you.